Here we're going to talk about the extradition of Adrian Barron, a UK citizen who is also a citizen of St Vincent and the Grenadines. Adrian Barron, who was a responsible officer of Beaufort Securities Limited, was extradited from Hungary to the US, has pled guilty to failing to comply with FATCA, and when sentenced, faces a maximum of 5 years imprisonment. To read directly from the indictment document itself, paragraph 78A. During a meeting on or about July 7, 2017 in Miami, Florida, between Barron and an undercover agent, Barron stated, in part, that Loyal Bank would not submit a FATCA declaration to regulators unless paperwork indicated obvious US involvement. Paragraph 77. In or about and between May 2017 and February 2018, both dates being approximate and inclusive, within the Eastern District of New York and elsewhere, the defendants Adrian Barron and Linda Bullock, together with others, did knowingly and willfully conspire to defraud the United States by impeding, impairing, obstructing and defeating the lawful government functions of the IRS in ascertainment, computation, assessment and collection of revenue, specifically by failing to comply with FATCA. Count 5. Count 4. Page 27, paragraph 74. In or about and between August 2016 and February 2018, both dates being approximate and inclusive, within the Eastern District of New York and elsewhere, the defendants Panayotis Kirisu, also known as Peter Kirisu, and Arvind Singh Kanay, also known as Vinesh Kanay, together with others did knowingly and willfully conspire to defraud the United States by impeding, impairing, constructing, and defeating the lawful government functions of the IRS in ascertainment, computation, assessment and collection of revenue, specifically by failing to comply with FATCA. The defendant, Beaufort Securities Limited, was a broker-dealer and investment management company located in London, United Kingdom. Beaufort Securities marketed itself on its website as a fully licensed broker-dealer regulated by the United Kingdom's Financial Conduct Authority, which serviced both institutional and private clients. Among other services, Beaufort Securities executed securities trades in the United States on behalf of its clients and then received the proceeds of those sales in its clients' brokerages accounts in the United Kingdom. Beaufort Securities was registered with the Internal Revenue Service, IRS, as a FFI under the Foreign Account Tax Compliance Act, FATCA. The defendant Loyal Bank was an offshore bank with offices located in St Vincent and the Grenadines and Budapest, Hungary. Loyal Bank held an offshore banking license from the Financial Services Authority of St Vincent and the Grenadines. Loyal Bank marketed itself on its website as an internet-based multi-currency private bank specialising in wealth management, private banking and investment banking for individuals and corporations. In or about 2014, Loyal Bank registered with the IRS as an FFI under FATCA. In connection with Loyal Bank's registration as an FFI, the defendant, Adrian Barron, was listed as Loyal Bank's responsible officer. Paragraph 7. The defendant, Adrian Barron, a citizen of the United Kingdom and St Vincent and the Grenadines, was employed as the Chief Business Officer of Loyal Bank and a Director of Loyal Agency. Barron primarily worked at Loyal Bank's office in Budapest, Hungary. Prior to being Chief Business Officer, Barron had been employed as the Chief Executive Officer of Loyal Bank between approximately 2006 and 2014. Paragraph 21. In or about and between August 2016 and February 2018, the defendants, Peter Kirisu and Vinesh Kanay, together with others, devised and engaged in a scheme whereby they agreed to defraud the United States by facilitating their clients' efforts to impede, impair, obstruct and defeat the lawful governmental functions of the IRS in ascertainment, computation, assessment and collection of revenue, specifically failing to comply with FATCA. Paragraph 22. In or about and between May 2017 and February 2018, the defendants Adrian Barron and Linda Bullock, together with others, devised and engaged in a scheme whereby they agreed to defraud the United States by facilitating their clients' efforts to impede, impair, obstruct and defeat the lawful government functions of the IRS in the ascertainment, computation, assessment and collection of revenue, specifically failing to comply with FATCA. Paragraph 25. In or about March 2016, following an investigation, the FCA found that the financial crime controls and anti-money laundering processes of Beaufort Securities were deficient. In or about July 2016, the Chief Executive Officer of Beaufort Securities affirmed to the FCA that Beaufort Securities had completed remedial actions to correct the deficiencies identified by the FCA. Notwithstanding these representations to the FCA, after July 2016, Beaufort Securities continued to facilitate market manipulation schemes, including executing sizable trades in pump and dump schemes involving at least 10 US publicly traded stocks. Page 9, paragraph 27. On or about August 28, 2016, a Belizean citizen, acting as a confidential source, CS1, emailed Beaufort Securities and requested information regarding the opening of a brokerage account at Beaufort Securities. In response, on or about September 1st, 2016, the defendant, Peter Kiriakou, emailed CS1 and provided his telephone number to arrange a call to discuss the opening of a brokerage account at Beaufort Securities. Throughout September 2016, CS1 placed a series of consensually recorded telephone calls to the defendant, Peter Kiriakou, to discuss the opening of brokerage accounts at Beaufort Securities. In these communications, CS1 advised Kiriakou that he represented wealthy US clients who wanted to deposit stock with Beaufort Securities. Kiriakou informed CS1 that Beaufort Securities did not open accounts in the names of US citizens because of tax reasons. CS1 responded that his clients planned on opening accounts in the name of Belizean offshore entities using Belizean nominees as shareholders, and that no US citizens would appear on any of the account paperwork. Kiriakou advised CS1 that this arrangement would be acceptable to Beaufort Securities. Paragraph 29. Beginning in or about October 2016, a law enforcement agent posing as an associate of CS1, while located in the Eastern District of New York, placed consensually recorded telephone calls to the defendant Peter Kiriakou and stated, in part, that he was interested in opening multiple brokerage accounts with Beaufort Securities from which to execute trades in several multi-million-dollar stock manipulation deals involving stocks traded on the US over-the-counter markets. The undercover agent advised Kiriakou that he was a US citizen and that the purpose of opening the multiple accounts at Beaufort Securities was in part to conceal his ownership interest in the company's stock from the SEC. Kiriakou responded, in part, "We can't actually deal with US clients due to tax laws." The undercover agent then advised Kiriakou that the accounts would be opened using Belizean IBCs controlled by the undercover agent and that no US citizens would appear in any of the account opening documents. Kiriakou then agreed in principle that the undercover agent could open brokerage accounts at Beaufort Securities. Paragraph 30. On or about November 30th, 2016, the undercover agent and CS1 met with the defendant Peter Kiriakou at Beaufort Securities' office in London. The meeting was consensually recorded. During this meeting, the undercover agent further explained the stock manipulation deals in which he planned to participate and his intent to use brokerage accounts at Beaufort Securities to execute manipulative trades in furtherance of those deals. The undercover agent emphasised that, because he was a US citizen, his name could not appear on any of the paperwork associated with his brokerage accounts. To that end, Kiriakou recommended putting CS1's name on the account paperwork as the beneficial owner, notwithstanding that the undercover agent had informed Kiriakou that he would be the true beneficial owner of the accounts and would be exercising full control over them. The undercover agent once again advised Kiriakou that his brokerage accounts at Beaufort Securities would be opened in the name of Belizean nominees, including CS1. During the November 30th, 2016 meeting, the defendant, Peter Kiriakou, introduced the undercover agent and CS1 to multiple Beaufort Securities employees, including a senior member of the compliance team, Compliance Officer 1, an individual whose identity is known to the grand jury. Kiriakou informed Compliance Officer 1 that the undercover agent was from the United States and was interested in opening brokerage accounts at Beaufort Securities. During the meeting, Compliance Officer 1 reviewed various account opening documents for the undercover agent's brokerage accounts. The documents included a form that defined FATCA and stated, its primary aim is to prevent US taxpayers from using accounts held outside of the US for tax evasion. Neither this form nor any other account opening documents referenced the undercover agent. Compliance Officer 1 did not object to opening brokerage accounts at Beaufort Securities for the undercover agent. Paragraph 33. In or about January 2017, Beaufort Securities opened 6 brokerage accounts for the undercover agent in the name of his Belizean IBCs. Belizean nominees were listed as the beneficial owners of these brokerage accounts, notwithstanding the undercover agent's actual beneficial ownership of the accounts. At no time did Beaufort Securities request FATCA information from the undercover agent. Paragraph 35. On or about April 26, 2016, the undercover agent met with the defendant, Peter Kiriakou, in London to discuss, inter alia, opening additional brokerage accounts at Beaufort Securities. The meeting was consensually recorded. During the meeting, the undercover agent once again described his participation in multiple market manipulation deals. Kiriakou again advised the undercover agent that Beaufort Securities did not accept US citizens as clients, but there were ways around it, including the use of CS1 and other nominees to open accounts. Kiriakou stated in part that the undercover agent's name would not appear on any account documents, notwithstanding that the undercover agent had informed Kiriakou that he would be the true beneficial owner of the accounts. Paragraph 57. On or about May 5, 2017, the undercover agent, while located in the Eastern District of New York, placed a consensually recorded call to the defendant, Adrian Barron. During this call, the undercover agent expressed interest in opening corporate bank accounts in the name of his Belizean IBCs. Barron and the undercover agent agreed to meet at Loyal Bank's office in Budapest in June 2017 to further discuss the undercover agent's request. Paragraph 58. On or about June 14, 2017, the undercover agent met with the defendant, Adrian Barron, at Loyal Bank's office in Budapest. The meeting was consensually recorded. During the meeting, the undercover agent explained that he was a US citizen and that he was a stock promoter involved in stock manipulation schemes. The undercover agent further explained to Barron that he was interested in opening multiple corporate bank accounts at Loyal Bank. The undercover agent informed Barron that these accounts would be opened in the names of the Belizean IBCs controlled by the undercover agent and that no US citizens would appear on any of the account opening documents, despite the undercover agent being the true beneficial owner of the accounts. Barron responded that Loyal Bank could open these accounts and provide debit cards linked to them. After this meeting, the undercover agent applied for a corporate bank account at Loyal Bank in the name of one of his Belizean IBCs and with CS1 acting as the nominee for the account. A Loyal Bank Limited Foreign Account Tax Compliance Act declaration form completed as part of the account opening application contained no reference to the undercover agent. On or about July 7, 2017, the undercover agent met with the defendants Adrian Barron and Linda Bullock in Miami, Florida, to discuss the undercover agent's relationship with Loyal Bank. The meeting was consensually recorded. During the meeting, the undercover agent described how his stock manipulation deals operated, including 1. The need to conceal from the SEC his true beneficial ownership of more than 5% of a company's stock through nominee brokerage accounts, and 2. The need to circumvent the IRS's reporting requirements under FATCA. Following Bullock's departure from the meeting, Barron joked that the corporate bank account of Loyal Bank, for which the undercover agent had applied, had no US involvement that he could see, despite the undercover agent's representations to the contrary. The undercover agent also emphasised that he required Loyal Bank's debit card service to provide kickbacks to the US-based brokers as part of his stock manipulation deals. Barron described the stock manipulations as pump and dump, or share ramping schemes, in which stocks are pumped up by a lot of fake news and everyone sells out, and the owners of those stocks are left with nothing. Paragraph 60. Following the meeting, the undercover agent requested that Loyal Bank open 5 additional bank accounts in the name of 5 more Belizean IBCs controlled by the undercover agent. Again, the undercover agent's IBCs utilised Belizean nominees. All 6 account applications contained identical business plans for each of the 6 IBCs. In or about and between July 14, 2017 and August 8, 2017, Loyal Bank opened 5 of the 6 bank accounts requested by the undercover agent. Notwithstanding the undercover agent's statement that he would be the true beneficial owner of the accounts, at no time did Loyal Bank request FATCA information from the undercover agent. Page 22, paragraph 64. On or about December 8, 2017, the undercover agent placed a consensually recorded call to the defendant, Linda Bullock. During the call, the undercover agent described his stock manipulation deals and again informed Bullock that he was the true beneficial owner of the bank accounts at Loyal Bank. Bullock stated in part that she was aware that these accounts had a nominee and that the undercover agent was not listed as the true beneficial owner. The undercover agent also described to Bullock how Loyal Bank's debit card service allowed him to provide kickbacks to corrupt stockbrokers in the United States. Notwithstanding this conversation, Loyal Bank continued to maintain the 11 bank accounts controlled by the undercover agent, and on or about January 30th, 2018, Loyal Agency renewed the 6 IBCs purchased by the undercover agent. Paragraph 65. On or about and between November 9th, 2017 and February 22nd, 2018, the debit cards sent by Loyal Bank to CS1 at the direction of the undercover agent were used to withdraw approximately $130,000 from the automated teller machines located in the Eastern District of New York.